So welcome to our session on climate change, legal considerations. Our speakers this morning are from one of our M&L partners, Stuart McKelvey, and they are Jonathan Dale and Christopher Goodridge. And I'll pass it over to them now for this presentation, which I know a lot of us are interested in just because climate change is a huge area of focus for us, but also everything that comes along with it. So over to you, gentlemen.
Hi, I'm Jonathan. Nice to see y'all. And that's Chris is an associate and I'm a partner at Stuart McKelvey in St. John's. So thanks for inviting us. We're happy to be here. We were asked to speak to something with an environmental bent to it. So we thought long and hard, and constructive expropriation is something maybe a lot of you have heard about. It's made some rumblings in the law in this province for the last number of years with some noteworthy cases. And it is something that we think is going to be coming up a bit more in the future as it relates to such things as conservation zoning, protected watershed areas, water runoff. So that's the sort of bent. So we are speaking about constructive expropriation because it does have a lot of interplay with environmental rights. So we want to talk first at a high level about land use regulation in Canada. Oh, perfect. Because we'll talk about Lynch, which is a case maybe some of you have heard about. So effectively, constructive expropriation is about when there's restrictions on property use. Am I coming through okay? There's a lot of
It's really try the wireless.
Is this one any better?
Yeah.
now if I talk. Okay, I'm gonna sit down. I like sitting down anyway. Normally in court we have to stand up, so I'll take the advantage of being able to sit and stand down. So as we talk about zoning, which we will shortly, I mean, it goes without saying that all municipalities are required by the Urban and Rural Planning Act to have development zones. So you have your urban and rural, your residential zone, your industrial zone, your conservation zone, your heritage zone, perhaps. And so by its very nature, any zoning that a town adopts has restrictions on development. I mean, if you own land in a town, there are certain things you're just not allowed to do on it. And there are certain things you are. And that's where a lot of friction happens between property owners and municipalities. Someone wants to put up a store. It's a residential only. Someone wants to build a mine. It's conservation. Someone wants to do something else. It's protected watershed. So the starting premise, because property owners always get quite upset about any restrictions on the use of their property, is that courts have been extremely reluctant. So just go back there, Chris, actually. So courts have been extremely reluctant to find constructive expropriation. It makes, no, I'll tell you when I want to slide. You're very anxious to get going. So constructive expropriation, when there's cases on it, it makes a lot of news. When Lynch came out, which we'll talk about shortly, it was, some people were talking as if the sky was falling. It hasn't fallen. Constructive expropriation remains the exception, and a very rare exception. And that's what we continue to feel. Because the courts recognize that municipalities have to be able to implement zoning decisions, which by their nature restrict development. And so it's a very heavy test, not yet though. Another thing we'll talk about shortly is Section 5 of the Urban and Rural Planning Act. And this hasn't received a lot of judicial consideration, but we think it's going to become more important and going to receive some judicial attention at some point soon. And that's a section that actually says a person just isn't entitled to compensation for a reduction in value of that person's interest in land as a result of a plan under the Act. And so at its highest, that would mean that if I owned a bunch of vacant acreage in a town, and all of a sudden the town said we're zone, and I was going to build a big condo on it or something and make $1 million. And then all of a sudden, before I got my permit, the town changed it to a conservation zone. I lost my ability to develop it. Section 5 would mean I can't recover any money as a developer. So it's a huge protection for the town. It hasn't received judicial consideration yet. And I think it's because the test on constructive expropriation is in any event quite hard to meet. Okay, we can go to the next one there, Chris. And okay, so constructive expropriation. We want to start right at the beginning of what constructive expropriation is, because it's hard to talk about the recent developments if we don't have a little bit of a framework. So constructive expropriation is different from real expropriate, from statutory expropriation. So under the provincial legislation, if a town needs land for a school or a road or a hospital or a town hall, or you want to build a recreational facility, you have the ability as a town to seek ministerial approval to expropriate the land. And that's a statutory expropriation. That's when you write the minister and say, we want to expropriate Jonathan's land so we can build a school. And if the minister says yes, well, then you go through the legislative process, you get a document, you serve it on me, and that's it. 10 days after that, the town owns my land. There's nothing I can do about it. And all that's left is how much the town has to pay me. The town certainly can't expropriate someone's land without paying under the legislation. So that's a legislative expropriation. Constructive expropriation is what happens. It's a common law thing. So it's not a legislative thing. And so effectively what constructive expropriation is where a town has done something, where the town has acquired a benefit from my land or an advantage, but they don't own my land, but they've essentially precluded me from using it. And so examples which we'll talk about in some detail is the Lynch case. But, and that's, 7 or 8 years old now, but, if you folks were in this sphere back then, you would have heard a lot of people talk about it. And that's St. John's watershed one, where around Windsor Lake, there's no development. Of course, there's not. It's a protected watershed, and you can't have people boating around in Windsor Lake. And the court held, but people owned it. So regular people own the land right on front of Windsor Lake. If you could build a cabin there, you'd sell it for, a fortune, right? I mean, the land would be very, very valuable, except the land that these people owned was in a protected watershed. They couldn't develop it. And so that's the constructive expropriation case that worked its way through our courts. And the court said, okay, although Jonathan still owns that land, it can't be developed. The city's acquired a benefit, and that's constructive expropriation. And so compensation is payable. So the theory is the town hasn't gone through the legislative process of acquiring title to my land, but what they've done has reduced the value of my land to effectively nil for the benefit of the town and protecting its watershed. But it wasn't new law. It's the test, the leading cases from the Supreme Court of Canada is from 2006, Supreme Court of Canada, CPR, and R versus Tenor in 1985. So it was just, I think what was earth-shattering about it is we're a small province. That could be a very sizable claim. And water usage. Almost every town has some sort of protected watershed area or municipal water or these sorts of things. So you can see this coming up in any town. So that's it at a high level. I think, Chris, are you on for next one? Okay.
So, and Jonathan's touched on this a bit earlier. And before I talk about my slide, I will say we missed out obviously on the previous presentation. It was a full house, so everyone's hitting the highway to start their weekend. But fair enough. Well, it's all we can do. But no, we're glad to have everyone here. So when we talk about why expropriation matters to municipalities, as Jonathan pointed out, this is a real concern for municipalities as it is. They're making these zoning decisions on a daily basis, maybe not daily, but they're making these decisions in their municipalities, and there is a risk to them that they might face some exposure. from people that are impacted by it. And we've seen it, for example, in the Lynch decision that's been moving through our courts. And there has been a finding now that it was a constructive expropriation. And now the matter's proceeding still before our courts. And it's actually going to the Supreme Court of Canada on a decision on the basis of like, how do they quantify the impact to the Lynch family for their expropriated land. So that's not what we're talking about today, but it's obviously a concern. And then even more recently now, we've had decisions, and I'm not trying to focus this on St. John's, but the KMK decision. So that was a decision where the city, you might have saw in the news, there was a large house in city center on 3 acres of land, and the city zoned it last minute after it was sold as a heritage building. And the owners of it felt that it severely restricted their ability to develop the land. They wanted to put a big high-rise development there. And so they challenged it. And we've had a decision now in 2019 from our court that said it wasn't constructive expropriation. And then moving on more recently, and this will become the focus of our presentation to some extent, is this Annapolis decision, which came out within the last year from the Supreme Court of Canada. And there's a lot of concern now from lawyers and the dissent. So in Annapolis, there was a 5-4 decision split, which meant 5 judges went with the majority and 4 went with minority. And the minority really thought that this change that's coming from Annapolis is going to impact municipalities and increase their exposure significantly to these types of claims. So that's really why it's relevant right now. And that's why Jonathan and I are here talking about it. So was there anything else you want to add on that, or is there?
I just add, the KMK case, it was in St. John's, but I think every municipality can see why it's relevant for them. It was about a heritage building, and perhaps even more so for some of outside of St. John's area, where you've got these older houses, your nice small downtown core, which you want to preserve. And then all of a sudden someone's building a huge shack next to it, and it ruins the whole vibe of what you got going on in your community. And so, that was what was heritage. That was what KMK was about. I mean, the person who bought this heritage building, the company, they wanted to flatten it so they could turn it into condos. And the court said, and the city said, no, you can't. It's a heritage building. And then they said, well, you've constructively expropriated my land. You're not letting me build the most profitable thing I want to build. And the court said, that's not what the test is for constructive expropriation. You can still keep it as a heritage building. And so the KMK lost. So that's a good decision for you folks. And so keep that in mind.
So as I mentioned, we are going to be talking about this Annapolis decision. So what Annapolis really involved, I think it's good to give you some context to it. So Annapolis was within the Halifax municipality, and it was a developer in the 1950s. At the time when he started acquiring the land, it was available. It had no zoning designate or development restrictions on it. It was open land. He could have done whatever he wanted on it at the time. So he started acquiring all these swaths of land outside Halifax. And then in 2016, as the city grew, or 2006, sorry, as the city grew, Halifax started developing a strategy for how they wanted to basically control their growth as a municipality. And then in 2007, the developer applied to develop the land. And in 2016, Halifax passed a regulation that effectively said he couldn't do anything on it. Now, he might be able to at some point, but they passed legislation. It was a significant amount of money they had spent, almost 1,000 acres of land, purchasing it for this purposes. And the city of Halifax said, no, you can't. And they passed a regulation that severely restricted it. So obviously the developer sued, and it's been working our way through the courts, and it went as high as the Supreme Court of Canada. And that's where we've got this new change in the law to how you determine whether or not constructive expropriation has happened. Yep.
Okay, so this is a legal test, and the old test on the left side is the test that would have been applied in Lynch. It's the test that would have been applied by KMK. It's a test that's been applied right up until about 6 months ago when the Supreme Court of Canada ruled in Annapolis. And although these are 2 small bullets in each, I don't know if you've ever tried to wade through any decision of the Supreme Court of Canada, but you'd be amazed how much ink gets spent on what the word advantage means as opposed to what beneficial interest means. And that's really where the potential change is. So if you look at the old test, the two-step analysis for constructive expropriation, this is what the Lynches had to prove and what the court found that they did, is that the municipality or government acquired a beneficial interest in the property. And so in Lynch, they found that the city acquired a beneficial interest because we got to preserve the city's water. But as a result of you not developing your land. And the second element was the removal of all reasonable uses. And certainly the Lynches weren't allowed to develop. So that was the old test. Now we say new test here. As Chris mentioned, there was a dissent in Annapolis, and for lawyers who practice in litigation, the hardest thing in the world is when the Supreme Court of Canada can't even agree on what the law is, because what the hell do we do when we go into court? So, you know, it was a majority decision. So the majority is the law, but when there's a dissent, what that means is, in my view anyway, is that the law hasn't really settled down yet. There's still some uncertainty, and things are going to have to work themselves out through later decisions. But the new test, the main change was in item 1, where the owner, where now the test is, as opposed to having to establish the city having acquired a beneficial interest, the owner needs only prove that the municipality gained an advantage from the regulation. And I think, you know, as Chris and I have gone through the old cases to try to think about it, it's hard to actually find a case where you'd say, well, there's an advantage, but not a beneficial interest, or a beneficial interest, but not an advantage. But that change in word is the reason why there was a dissent at the Supreme Court of Canada, because they said the test is not an advantage, the test is beneficial interest. And then they spent pages and pages talking about how they could be different. The second element of the test, and we'll talk about this in a bit more detail later, but the second element of the test is always, I think, the most important one for municipalities, governments, and so on, because this is where the hurdle is so high and has stayed high, is that you have to remove all reasonable use. And so that's why a heritage zone in KMK wasn't found to constitute constructive expropriation. It's because although you who bought Bryn Mawr would like to, you know, develop it in a more financially profitable way, you can still use it, fix up Bryn Mawr, and use it as a big home. We haven't removed all reasonable uses. So the right of compensation is never about a property owner thinking, I want to do something that would make me more money than what the current zoning allows. That is nowhere near the test. If that was the test, you'd never be able to make any zones, period. Okay, I think I'm good on that one, Chris.
Yep. So again, I'm going to flick back just briefly, like, again, as Jonathan pointed out, like beneficial interest versus advantage, like what is that even really, like, how is that different? And for that reason, we have the judges can't even agree on it. And so when you look at it, the court in the majority is they really want to emphasize and say, like, look, we're not changing the law. We're just bringing some greater clarity to it. And the reason they talk about bringing greater clarity to it is because what they found that courts were doing is that they were really looking and saying, if we're going to make a finding on constructive expropriation, there has to be some identifiable, like, proprietary benefit flowing to the city or the municipality or whoever it might be. And so just flipping back to Annapolis, in that case, and we're not going to get into the weeds of it all, but the town of City of Halifax had a park right next to it. And there was some evidence that they were advertising people to go hike on these private lands. Now there's no determination on that yet, and it still has to go to trial, but that would be the type of thing that they might consider as like, well, look, you're clearly getting an advantage. You're advertising it and you're letting people go out on this land to hike on it. And so they were looking at that. And when you look at Lynch, for example, which was the beneficial interest test, they said, well, in that case, you're getting the benefit of water flowing over the Lynch property and getting clean water downstream for your watershed. That is a clear benefit that you're getting from their property flowing to you. Whereas, so like, it's challenging to kind of stick handle it a bit in my view, because what the court, the majority or minority now thinks is that, well, by saying advantage, like, what isn't an advantage? Like, of course, if a municipality is making a zoning decision, how are they not going to get an advantage of having an open space? Well, is it an advantage that they've got more green space in their town now? Like that could easily be an advantage. Or are they getting the advantage of a watershed, preventing flooding claims, advantage, or keeping the heritage status of their properties that make people want to come visit their town and see the heritage properties and whatnot. But fortunately, and I know Jonathan probably wants to jump up, but we have that KMK decision where the court said is that, and again, we've got to recognize this, so I'm careful, but KMK was on the beneficial interest one. So on that case, and I don't want to confuse you, but the court said there was no beneficial interest. So when we try to stick handle, as I said, Lynch, you've got a benefit of the water rights. That's a clear benefit the city's getting. But in KMK, the court said, well, like, what's the benefit really flowing to the town for a heritage? So it's yet to be seen, and KMK is being appealed, but potentially on that new test, the advantage test, they might say that a heritage designation is an advantage. So that's something that might like change it a bit, but we'll see. Our Court of Appeal is going to hear that matter. So I know it is confusing. I don't want to belabor it, but I do think in a lot of the cases that they have is there is that identifiable like concrete benefit coming to the municipality. And
yeah, I think when we get into the cases, it'll come out a bit more. So because it's hard to talk about in the abstract. But I think the key point from what Chris is saying and what you said is that the Supreme Court of Canada changed the language of the test from a benefit to obtaining an advantage. And the Supreme Court of Canada, the majority of the Supreme Court of Canada said, we're not changing anything. We're just providing clarity. But they went through about 30 pages of the decision trying to explain why they weren't changing anything. And the dissenting Supreme Court of Canada judges had their arms up in the air saying this changes everything. And so it's in that context that we're here saying, well, we have to see how Annapolis is going to play out in the future. Lynch was noteworthy because it was a fact finding in our province relating to water. Annapolis is noteworthy because the question is whether has it changed the law? Has it made constructive expropriation claims easier, which is not what municipalities want. And I don't think it's what the Supreme Court of Canada wanted, but this has to play out. So we talk about part 2 of the test first and give you a couple examples, because part 2 is the section of the test which was always the highest hurdle for a property owner claiming constructive expropriation. And so in that sense, this is the one for us representing municipalities where we focus. And so I'm quite happy the court didn't really change this much. They did have some commentary on it, which we'll talk about. But the key point is that to get constructive expropriation, not only does a town have to acquire a benefit or an advantage, but all reasonable uses have to be removed. And you can't stress that enough. It's all reasonable uses. And so, as we talked about before, this gives significant deference, and our courts, Supreme Court of Canada, KMK, all of them talk about how important it is. I mean, towns are required by the Act to make zoning. And if by the very virtue of making zoning, which limits development by definition, then that can't give rise to a constructive expropriation claim. There needs to be something more. So the types of zoning, though, that can potentially open the door to constructive expropriation claim, are typically around environmental considerations. And so they're typically around water usage. They're typically around conservation zones or agriculture and heritage. And so KMK, which we talked about, was a heritage zone decision, and KMK failed on that one. I think I've already mentioned what the factual circumstance was. And in that court, I think KMK was very misguided in the court proceeding. They had all kinds of experts march in and talk about what the most profitable use of that land would have been. And every one of them said the most profitable use would be to tear down Bryn Mawr and develop huge $1 million homes or a condo. And the court said that does not matter at all, because this is a heritage zone. You can keep it as a heritage zone. You can keep it as a heritage home. You can fix it up. And so the city hasn't removed all reasonable uses, and you lose. And so it's not about what the most, so I think that's the key point, because I know residents are always coming to town saying, I want to build a 3-story house, or I want to build a shed that's bigger than what your development regulations say. And you know, then maybe they'll spout off constructive expropriation. It's not. Conservation is where it's going to get dicey. It's always been dicey, right? And so it depends on what the purpose of the conservation zone is. Lynch, I think we can all, with the benefit of hindsight, look at Lynch and feel like it does seem a bit unfair that someone owns land on a pond and they can't do a thing on it, and it's for the benefit of all the residents of St. John's and the people using this water, and I don't get a cent for it. I mean, the town is getting something on my back. That's effectively what it is. But the key thing in Lynch that some people lose sight of is that they did remove everything. The city of St. John's really said, you can't do a thing there. So that's the difference, right? If it had been a conservation zone where they said, this is conservation, but you can build a small house, then I don't think it would have been constructive expropriation, right? Because there would have been a reasonable use, even though that's not what they would have wanted to do. Agriculture is also unlikely to be a removal of all reasonable uses. I know, you know, towns face that pressure, as we know, as towns are growing out, and then the farming land becomes valuable for residential development and urban sprawl and so on. But that's still a zoning decision. A town can zone it whatever it wants. So I don't see a constructive expropriation claim succeeding because someone has agricultural land and says, I want to build on it.
The other thing too I'd add, Jonathan, is the KMK decision, the zoning only applied to the building itself. And the court did note that and talk about it and saying like, look, this designation was only to this manor that was on the property, but there's tons of other portions of land that could be used. Now, whether or not it would impact the development, but they did say like, look, you've still got all this other land that can be developed if you wanted to. And so there's that reasonable use. And as Jonathan pointed out, it still can be used as a house. So it is a very, very high hurdle to get over to show that there's been a removal of all those reasonable uses. And in the Lynch one, it was very specific, I think, to the fact that there was a letter from the city manager saying you cannot do anything on this land. So again, so I'll just check briefly, and I know I don't want to belabor it, but this focus on the old test was that acquired a beneficial interest. And so we have no case law really talking about that yet, but the focus is obtaining an advantage. So what that means is yet to be seen, but it does seem to at least lower it a bit and make it easier to establish that there has been some advantage flowing to a municipality. And like, in terms of the beneficial interest here, like when we talk about it, so the cases that we've seen, so if we're thinking beneficial interest, so Lynch, as we said, water, city got rights to clean water. There's some other cases though that we've seen. So in a case called Tenor, in that case, it was a province and the province had a provincial park, and the Tenors had a mineral license rights to take out explore for minerals on that provincial lands. They were able to do that. And then the province passed legislation that effectively banned any development. And in that case, the court found in favor of the Tenors. And the factor there was that they changed the circumstances. The Tenors had a right to go explore on the property, and the city or the province implemented legislation that prevented that. And so they no longer could do anything. And the benefit that the province got was that there's no development happening in their provincial park. And so that, like, the court viewed that as being a beneficial interest they got. They took away Tenor's right to do something, and they got the benefit of not having it there. Would that still be an advantage? I would think so, yes. But like when we're trying to distinguish on cases where they might not find a beneficial, or they might find an advantage but not a beneficial interest, you got to really look at, like, was something being taken away, I think, and was that whatever was being taken away the benefit to the province or the municipality. So it's not easy, and I don't want to confuse you, but if we're trying to find a way of getting to it, I think KMK is an example where it was on the beneficial interest. So what did the city really get? Like there's nothing actually flowed to them. There was no conveyance. Sure, you can make all the arguments on the advantage test, but that didn't exist when KMK was decided. It was a beneficial interest. So what did the city get? Nothing really flowed to them. It was just a heritage designation. It's different than the benefits in that tenor case. And I know it might be difficult to distinguish, but we'll hopefully get some more clarity as this advances. But as we said, the focus is that, and it's tough. I don't know if you want to.
I think I was surprised when I read KMK. I always thought they were going to lose on the second stage, which they did, where the court held that the city hadn't removed all reasonable uses. And that's all you need. I mean, the property owner needs to establish both of those elements. So that's why the second one is always the one we go to first in representing towns, because there is some use allowed, it's reasonable, you can't win, period. But the court in KMK also found that the heritage designation by the city didn't provide any beneficial interest to the city. And that sort of surprised me. I mean, we know why cities put in heritage zones. And I think that's because under the old test, maybe beneficial interest was really defined as, are you taking something or are you just getting a benefit? And so that's where I think, and so that's why I think the Supreme Court of Canada, when they changed the language of acquiring a beneficial interest to obtaining an advantage, they're trying to say you don't actually have to take anything, but are you getting a benefit from? And so I think if KMK were before the courts now following Annapolis, that it's possible that our court might say, well, heritage zoning does in fact confer an advantage on a municipality. So that might be a slight change in the law or an evolution, or whatever you want to call it, but they're always going to lose on the second stage anyway. Second stage is really where the reason why we don't see constructive expropriation claims every day, right? Okay.
The other thing too that's worth noting is that in Annapolis, which was the town changing the zoning for that 1,000 acres of land, in that case, the Court of Appeal, which was, so there's trial Court of Appeal, Supreme Court of Canada, the Court of Appeal really focused on, like, there was no transfer of anything to Halifax. And so when it went to the Supreme Court of Canada, they really wanted to emphasize, like, this is a point of confusion, obviously, and courts are looking for that transfer of proprietary interest. But that's not what it's meant to be. And that's why they changed it to the advantage, is because courts were looking for almost like that paper transaction of showing, like, look, you're getting, it's coming to you, you're taking something, but that's expropriation. That's a whole different thing. And they have their own legislation for that. So that's why they wanted to stray away from beneficial interest and shift to the advantage. Another change that came from Annapolis that is interesting to some extent is they've added these 3 factors. And again, it's tough because we've got no cases on how they've been applied yet. But the court effectively said that, like, we're going to give you these 3 new factors that you should consider when we're looking at both elements of the test, the advantage and the reasonable uses portion. So you can look at them there. And nature of the government action, like, Jonathan and I chatted about this, and it's really unclear, like, what does that really even mean? Is that the nature of their decision? Like, what was their intent, or was it were they doing it just singularly to that property owner, or was it broader? I guess you could kind of look at that aspect of it. The notice, so at the restriction, and then the next one, the time it was acquired, and whether like the owner's reasonable expectations. And that would be things that, if you look at Annapolis, when he bought the land, it had no zoning restrictions. But now, as they've implemented these, it's changed it. So those are things you might be able to consider. How they'll change it, yet to be determined. The other interesting aspect is that the court made a point of saying that a steep reduction in value of the property is not relevant. Like, we're focused on uses. So just because the use might not give you a lot of money in your wallet, that doesn't matter. If it's a use, it's a use. But then if you look at this third element here, they talk about regulation that leaves the rights holder with only notional use of the land deprived of all economic value. So again, it's somewhat confusing, because you're saying in one part of the decision that focus on the use, but then there's factors that we can consider that talk about the economic impact to the value of the land. Now, so we'll see how that all comes into play, but I still think the focus needs to be on the use, and that's the main elements there. So as long as a municipality can show that you haven't deprived that owner of all reasonable uses, it'll be good for the town. Like that's still the test. And these factors, they're not the main testing you do, they're considerations. So as long as there exist those uses and then even if there's an advantage, it doesn't really matter. If the uses exist, then you're good. Simple fucking form, but
So, that last slide, it was dense. That was essentially cut and paste from how the Supreme Court of Canada talks. And you can see how they can say things and then very quickly you go cross-eyed trying to think, how does that apply to a specific fact circumstance? And so that's why we need to wait to see, has this really changed anything, as the dissent said in the Supreme Court of Canada, or has it changed nothing, which is what the majority said. The majority very much said, we're not changing the test, we're just putting a bit more meat on the bones. And so that was the meat on the bones that Chris just had in that prior slide. It's certain. Oh, sorry. Yeah. Well, we have a couple more slides, then we actually are going to break for questions on this. So just go back to the next one then. So one thing the court did say in Annapolis, the majority of the court did say in Annapolis, maybe to avoid the concern of or perhaps mitigate the concern of the dissent or a potential concern of provinces, is the court in Annapolis actually said, look, this is a common law claim, constructive expropriation. There's no legislation out there that says to claim constructive expropriation, you need to do blank, blank, and blank. It's a judge evolved concept through the courts. And so the court said in Annapolis, effectively, look, if provinces don't like constructive expropriation claims, they can put in their legislation, you can't have constructive expropriation claims. And so Section 5 of the Urban and Rural Planning Act very much looks like what the Supreme Court of Canada in Annapolis was saying, where it says a person isn't entitled to compensation for a reduction in value of that land or a loss in it resulting from the application of the act or a plan under the act. So this hasn't been judicially considered. I don't know if it's going to be as judicially, as interpreted as broadly. You can imagine lots of fact situations where the court is going to say Section 5 doesn't allow towns just to run roughshod over everybody and just, call your land just open space, incapable of development, knowing that you bought it yesterday, for a fortune. So there has to be a principal basis of implementing plans in any event. So that's captured by good faith obligations and so on. But I guess what I am saying is that the Supreme Court of Canada expressly recognized that there could be a statutory prohibition against constructive expropriation claims. And Section 5 looks very much like what the Supreme Court of Canada seemed to have been contemplating. And there have been prior cases. So a case called CPR, I think it was the 2006 case out of the Supreme Court of Canada. That one was in Vancouver. And in that one, the city of Vancouver had a very similar language to that Section 5. And the Supreme Court of Canada said you can't claim constructive expropriation. So I think part of the reason it hasn't received a lot of judicial consideration is because they were always going to lose under Section 2 anyway. And this wasn't really at play in Lynch because Lynch had a whole different legislative framework involving the City of St. John's Act and so on. So we're very interested to see what that means. Is this me?
yeah.
So another thing that doesn't come up much, but always has the prospect of coming up, and you sort of wonder why, but could also come up in environmental claims, but for 98 is a purchase notice. So effectively that lets a person go to the minister, isn't it?
Yep.
Yeah. So you go to the minister and you say, look, I have land within a town. The town has, as a result of their conduct, has made it incapable of reasonable beneficial use. If they've prohibited the use, and it can't be capable of any reasonable beneficial use. And so essentially then you send that to the minister, and then the minister has the ability to look at it, look at the elements. Section 97, which we don't have there, also has some additional elements. But the end result is the minister might say, yeah, city, you have to pay this person for the land. So as it relates to environmental issues, though, which is more the focus in bringing this up, is section 98, where it effectively says you can't use a purchase notice as it relates to watershed or another environmental reason. So that is at least a clear statutory bar as it relates to purchase notices. So, you know, very, very important. You know, I've been practicing municipal law for 15 or 16 years, and then, you know, people more senior than me too. And I don't think, you know, within our firm, you could come across anyone who's ever had to help a town out on a purchase notice. It's just not something that's used, but you wonder why. And then all of a sudden, maybe it catches someone's eye, and then all of a sudden it becomes the next thing you're struggling with. So it's there, and hasn't really been availed of.
And I think too, just to add on that, like in the cases that have dealt with it, there's very few. In those cases, the person that applied for it was unsuccessful. And one of the things the court talked about is that he had uses on the land that was already there when he had a shed, he had other pieces of property on it. And they said, well, you can still use it for those things. So there's no issues. And so I think municipalities, like, it's there, but the concern is we haven't seen it that much. As Jonathan noted, in the cases that are out there, the municipalities were successful. So the other point we want to chat about, and I know that the theme of this has kind of been on environmental concerns. So we shift now. So we've been talking about whether expropriation and constructive expropriation and compensation that might be payable, but also under our Water Resources Act, there is clear statutory language that when the province or municipality designates a public water supply area, then the owner of properties that are impacted by that, and you can look at it, what it says, that it detrimentally affects the owner of that property, will receive compensation for that injury. So, like, look, like, we've looked at this, and it's all like legislation's never straightforward. We look at, so it says this and this one, that they're entitled to compensation for a public water supply area, but then when we look at the section that Jonathan just went through earlier, and I can flick back to it, is section 98, notwithstanding, they're not going to be liable for purposes of protecting a watershed area or other environmental reasons. And it almost seems to contradict themselves a bit, but I think when you look at the Water Resources Act and the way it's worded, it is clear. It is likely that if you designate something as a public or protected water zone, you are going to be potentially liable for paying out compensation, and that's the clear statutory language there, and then go to arbitration and have a determination on that. But again, the point we want to emphasize is that it is unclear, and there's different legislation that says different things, and whether or not this language might change now, because again, it references reasonably beneficial use. Whether that might change to advantage is yet to be seen. But I think, yeah. So, but and then shifting forward, I guess, is when we're looking at like pain points for liabilities. So this is what really matters to you guys, is like, where is the exposure really out there? And so conservation zoning, that's really the one that might have the most traction for property owners.
I think, just to jump in there on that, is, you know, we're not trying to create fear. I mean, towns have conservation zones all over the place. It's really just what are the circumstances that give rise to the conservation zone, right? Because Annapolis, what the facts as alleged were that the city of Halifax essentially called something a conservation area or whatever the zone was. But the real purpose, as alleged in the claim, was that they just want it as a park, and they're encouraging people to come walk through this beautiful vacant land. So, you know, I mean, I think we all know you can't just call someone conservation land because you know the residents love having picnics there. Conservation, if it's done for the right purpose, the right intent, then it shouldn't give rise to a claim for constructive expropriation. But you also look at the history of it as well. It might even get into are the restrictions, if you look at the purpose of the conservation zone, are the restrictions on use the bare minimum so as to achieve that purpose? So, I think we're going to get into the weeds more as it relates to conservation zones, because they are the zones that are, the most infringing on someone's real property rights. And they're the most challenging. And but I think it's going to be an exercise of what is the purpose of the conservation zone? What's the history of it been? Has this been a vacant marsh for the last 50 years? And so, I mean, it's maybe not conservation zone, but we just called it conservation. You could never have really thought it was going to be anything other than that. So, but that's sort of what the Supreme Court of Canada is saying, that they're suggesting a bit of a deeper factual dive, I think, is what they're saying.
Yeah, no, definitely. And again, moving on, like heritage zoning, we've talked about numerous times here, like we've got that beneficial decision from the KMK, whether that will change on the Court of Appeal. But again, the focus is these reasonable uses. So like there are cases out there, and I don't want to get too far into them, but like in the previous one, CPR, for example, that was in Vancouver. In that case, it was which was Canadian Pacific Railway, had a railway track that would come into the city of Vancouver, and it was designated as a zone for transportation in and out of the city. And CPR applied to have it upzoned so that they could use it. Obviously, Vancouver, we all know, has had huge increase in property value. And in that case, the city said no. They said, no, you can't. And then they appealed it, and the court looked at it and they said, well, not only does the Vancouver legislation limit liability, but also you haven't removed all reasonable uses. You can certainly still, if you want to run train tracks down there, sure, that's a use and you can still do it. They're not banning you from doing anything on it. You still have the rights you always had. And so that's kind of where, when we think about this, is not trying to get too caught up in the advantage portion, because again, there's two elements to it and you've got to remove all those uses. So it's going to be difficult. We think that to establish both of them, and the Annapolis decision, I think the change in the language to that advantage really, it does help municipalities. Sorry, not to change to advantage, but sorry, the reasonable uses is making it clear that like you've got to meet both of them, and whether that will always happen. I noticed there's a bit of static there, but whether that will happen is challenging. Sorry. Oh, perfect. Is that better? Yeah, perfect. So I don't know if there's anything else you want to add there, Jonathan, or if it's worthwhile to get into some of the more of the.
I think the next slide is questions in any event, and I suspect if there are questions, we'll probably just end there, because I think 10:30 we're done.
Yeah.
Small municipality, we do a development plan. The development plan says this is a zone, and these are the only type of dwellings allowed in this zone. If someone decides to put, and it's been in the news, a tiny house, there's an example in there. It does not fit the criteria of 862 square feet of a single dwelling. So towns are saying, no, you cannot do this. If someone decides to put a recreational vehicle, a trailer, in a zone that's for permanent dwellings, they're not entitled to do that, correct?
I mean, it's all in reference to what your regulations say. So if your regulations say in this residential zone, any house has to have a minimum square footage a footprint of minimum blank, and they develop it at less than that, or they apply for a permit than less than that. Well, I mean, if it's not a permitted or discretionary use, then you actually have to reject it. And if it's a discretionary use, and council can consider it, and they can accept it or can reject it. But decisions on development applications, those are decisions that, if you reject it, or if you issue a removal order, if someone builds it without seeking a permit, those are decisions or actions that get appealed to the regional appeal board. So it's not, I don't see that as a constructive expropriation claim so much as a decision regarding a development regulation. You certainly haven't removed all reasonable use. You're just not letting them do what they want to do. And so, because you do see that a lot, and that is something we see a lot is the tiny homes, right? But I see that more as pressure on municipalities to create zoning, allowing for a tiny home region in your town. Or a RV home or a mobile home, whatever the proper term is for that. But those are zoning decisions that I don't see giving rise to constructive expropriation claims.
Okay, so the next question is, the development plan is 20-some years out of date. It has not been updated because no one wants to do it. There's no money, whatever. Could they use, because we're going through this, could they use the fact that our development plan is 20 years out of date to say that it's an irrelevant document, even though it's been signed by the.
I don't know. That's interesting. I mean, certainly, I think there's something in the Urban Rural Planning Act, the Municipalities Act, saying they're supposed to be updated every 10 years.
Every 10 years. Exactly.
But I certainly haven't seen anything that says they become obsolete after 10 years. And I've done a lot of work for a lot of towns where I see that they are a lot more than 10 years old. I've never been challenged by anyone when I'm saying this is the regulation. It's certainly what the town considers to still be applicable, although it should have been updated and so on. But and I think there's even, and I forget now offhand to the scope of their application, but I believe there's interim development regulations under the Urban and Rural Planning Act. Well, I know there are. I just don't know if at the end, if there's a schedule that says they apply to all towns or just certain towns. So, you know, I think that will be the fallback in any event, is that the interim development regulations. But I certainly don't see how any resident could ever possibly succeed in saying your town plan from 15 years ago wouldn't have allowed my development, but it's expired. And so now I can build whatever I want, wherever I want. I don't think that has any prospect of succeeding.
And my last one.
Actually, we do have another question, so
Oh,
if,
sorry.
just let the gentleman go first, and then if we have time, we'll get you to come back.
Okay, I won't, I was open for more time, but it's how we can do. Dave Viscak, Buena Vista. Everything that you talked about there in the last hour, we're going through right now.
Sure.
Almost identical. And I wanted to sort of pick your brains because one thing is, we got an heritage house circa 1840. So it's almost 200 years old. It's in a mixed use area right in the center of town, and Buena Vista has been restoring a lot of the old houses. And the house, kitchen burned out. So the lady wanted to tear down the house and build a modern bungalow. And we said no, but we found out something interesting. We said no, and then she started rallies that became protests, and the protests got out of hand, and the mayor had $12,000 worth of damage done to his house. But we found out something good that came out of all this. Apparently, and you guys as lawyers would know, or you soon will, that because of the uprising in Ottawa, anyone that organizes a protest or a rally now, and any damage that they can prove is done because of those rallies, is their sole responsibility, and they will be charged. So this has sort of slowed down the rallies or the protests a little bit, but guaranteed this one's going to court. So you'll soon have a new case that we'll wonder about. And the other thing, the other quick thing is we've been doing for years, and I'm expecting this to soon go to court, is you talked about vacant land. Cape Buena Vista is an heritage site, 6 kilometers from the last house down to the lighthouse. Now that we've got recently been approved for a UNESCO site in the geopark, I mean, tourism is going through the roof. Everyone wants to develop their land on the Cape. And we've been stopping it. We've had to go literally and knock on people's doors and say, you're not allowed to put there. If you do, you're going to court. Now, sooner or later, someone is going to take us to court on that. Now, it's like you talked about conservative or rural, and it says that rural can be developed if you got a comprehensive development plan. But we're not going, I mean, obviously, no one wants to come to Buena Vista to go out to the Cape and see RV parks and cabins and restaurants and everything like that. They want to see them, and we've been doing it. There's nothing out there. But the two of the things you talked about was like, and we were going to put a golf course there at one point. When we did the search, there were 80 grants out there. So people owns it now. We haven't been getting tested because probably the people who owned it in King George V or something like that, they're gone, and their relatives probably don't even live in Buena Vista anymore. But I'm not, and you know it's coming sooner or later. So the two things you talked about with the with the expropriation, and we didn't expropriate it. We just won't let anyone build on it, so.
That's what constructive expropriation is, or that's the theory,
That's not-
right? I'm not saying you have, but
We're going through
Yeah,
it right now.
yeah.
But you can watch for it, because this one that we're talking about now with the lady that had her kitchen burned, and now she wants to tear the house down and put a new bungalow right in the middle of the heritage area. That's gonna have to go to court, guaranteed.
I mean, it doesn't have to, I mean, I guess you'll see if it goes to court, but I mean, the question is, look at your development regulations. What developments
Under
are
section
allowed and
5,
prohibited,
Under
right?
section 5 in the mixed use zone, if you want to renovate your house or add any extensions or replace it or even repair it or even replace it, you
Yeah.
have to do it by the heritage regulations.
Okay, so there
This
you go.
lady wants to tear it down and put a new modern bungalow there.
Yeah, so
We've
that's,
offered her another site. We've offered her 4 different sites to pick from.
well,
Because
just,
the little piece of land she got is not out, because on the older houses were built on small pieces. So we've offered her land in the subdivision free of charge and everything, but no, she got her back up now, and of course it gets personal. And all kinds of mudslinging and worse, and so, but I just had this theory that the way that you guys are talking about exactly what we're going through right now.
I think part of it too, John, is like if that building it coming, that was just an aside, but like if the building's not safe for humans to stay in, like if the barn manor that we were talking about in St. John's, that's not fit for human, like that has to be torn down because it's just unsafe. It was destroyed. Now, this might be a small fire in her kitchen, but if the development regulations say that she has to build it in compliance with the heritage building regulations, well, then you'd think that's what should be followed.
that's KMK. Go on Canley and Google KMK and have a look at it, because that's pretty much exactly what it was.
Sorry, I'm gonna have to cut. I'm so sorry, because we do have to get into our last session, but I believe Jonathan and Christopher might be able to spare a few minutes. So if you want to pop out in the mezzanine or something, but thank you so much for that awesome presentation. Now you know why the Stewart McKelvey partnership with M&L is so valuable. So make sure you take advantage of all the services that they offer, and check them out in your booklet. Their bios are in there as well, and contact information is on our website and details on our partnership. So thank you again. Yeah, I'm going to move out of the way too to give you a minute, and we'll give the rest of the people a chance to trickle in, and then we'll move right into our next and final session for the weekend.
And we'll stick around, and I don't know if it's been mentioned, but we have a retainer with M&L where towns can call Stewart McKelvey and you get your 10 or 15 minutes, and we don't start the clock or anything. So don't worry about that. So, so that's what the whole purpose is for. It's paid for by M&L. So, those questions that you have, you can just pick up the phone and call our direct line, and we have that chat. So, okay, thanks.